Okay. So, and we don't have any attendees yet, but they might join us. But otherwise, it might just be us. So I will go ahead and take roll. Oh, we have some attendees. Brennelson?
Present.
Hamilton?
Unmuted and present.
Okay. Torres Ambris?
Present.
Great. And it looks like we have a few members of the public in attendance. So I think I'll like to start with a call for public comment. If there's anyone who's interested in commenting on the agenda item today, please use the hand raising function in Zoom. If you're calling in, you can do that by pressing *9. So I'll just give people a minute to see if anyone is interested in making public comment. I don't see anyone. Okay, so I guess I'll start by just advancing. I have just a few slides to help guide our discussion. And first of all, I wanted to welcome Claudia to this subcommittee. Thanks for your interest in participating in the development of the licensing requirements. I think this is great to have more participation.
Thank you for having me.
Especially since you're representing sort of the public and consumers. It's really great that you wanted to join us. So
thank you.
Just as a refresher, after reviewing the feedback that we got at the meeting on October 29th, these are now what was decided at the last meeting in terms of what the licensure requirements would be. So we expanded from just a JD to allowing for LLMs, and we expanded from ABA, just limiting to ABA and California accredited law schools, to also including the registered law schools. I don't think there were any changes made in the educational requirements.
I think that was one of the matters that we wanted the additional information for.
Right, and we have, and that, right, and I provided, I posted the curriculum from the different programs that I was able to find. It was interesting. I wasn't able to find it much from Canadian schools. There are a lot of Canadian schools. They don't seem to have their catalogs online the way that American schools seem to do, which was interesting. So finding the course descriptions was challenging. And even on some of them, I was able to find the course descriptions just on their website. But even when I went to print it, I don't know if you know, sometimes if you just go to print a website, it brings up all this gobbledygook that's layered over the top of it. So I think there was just one that I found I was able to print those in a readable fashion. And then we are also, in terms of getting input on subject matter from the practice area subcommittees, we've gotten a little bit of that from family. That's all that's currently meeting, since the last one is the family law subcommittee, and I'll share that with you. There was a recommendation to increase the practical training to 1,000 hours. And then, and I think that was the only other change that's gone in so far. Is that, do either of you have a recollection that's different from what's on the screen now?
No.
Nope.
Okay.
Are we going to get a copy of this PowerPoint?
Yeah, I can upload that to the Dropbox, and I can send that to you as well. So we also looked at more specific requirements for participants in experiential training for participants and then for supervising attorneys. And so this was some additional language. And in terms of this is one of the recommendations that came from the Family Law Practice Area Subcommittee about experiential training in a violence prevention clinic. And we need to get some clarification from them. It's not clear whether they've identified this area of violence prevention, which is domestic violence and elder abuse, and also some forms of conservatorship. Or
It's the civil restraining orders. So the workplace violence restraining
That's right.
orders.
That's right.
And the civil harassment orders.
Right. And what we weren't clear on from that was whether there was a recommendation that the violence prevention be a separate licensure, a separate practice area, or if that was going to fall under the family law.
No, the way that for Beriba and I have what we've recommended, or where I think we're going to end up, is that domestic violence will be a separate endorsement that will require this experiential training in violence protection clinics as part of the experiential. It'll have a separate educational component. So we're going through in family law, and if you're going to do this function, you have to have this education. And with the family law violence, which not only the prerequisite, or I should say the paraprofessional education's got to include it. It's got to be part of the MCLE too.
So you're taking the violence prevention out of the family law practice area.
No, I think it's still being discussed there because no one else is working on it. But what we're saying is, with that particular area of law, if paraprofessionals are going to provide services, you got to take it up a notch. You got to have specialized education during the paraprofessional program, as well as the continuing education, as well as the experiential.
Okay, so I still just want to get clarification. I know that the two of you are taking it up, but did you want to have that be not part of the family law, or it would be like a subcategory under for that? This is what I was trying to clarify. If it's going to be its own separate certification or fall under family law. I guess we can take it up further when we talk about family law.
Yeah, I think it needs to be part of family law, because if you're doing domestic violence restraining orders, you're dealing with custody and visitation. You're dealing with support, you're dealing with your requests. I guess if that should never be taken out of family law. The issue is whether the other ones, because we've created this homogeneous unit of any type of restraining order, maybe we need to rethink the other ones. I would not be opposed, but I can't speak for Fariba, to taking the non-family law restraining orders out of the family law category and pushing them back to general civil, because that's really where they belong. Okay.
So there's some back and forth on this.
Yeah. But the idea was specific to domestic abuse. There needs to, because there's specialized mental health and psychological education that needs to be part of anybody's education that is going to, I assume primarily assist victims, but would secondarily, probably provide assistance to the restrained party. And there's an ongoing need to have that education be continuing, not just a one-shot deal. And there's the practical benefit of doing the work in the clinics to get practical training.
Okay.
That's where we're headed with that.
Right. And so then I guess where this is relevant here is if you had someone who wasn't qualified or didn't have this specific training in the domestic violence related issues, then they couldn't handle those types of cases that came to them as family law cases. If there were domestic violence issues, they'd have to send that to somebody else to.
Right. They need the domestic abuse / domestic violence endorsement in order to provide services.
Can I suggest something?
Always.
for Stephen to take to the Family Law Subcommittee. My feeling, just based on what you said, is I think to parson out that element doesn't quite make sense. I would suggest to include it for just working in family law altogether, because I can't imagine starting some family law case and then finding out you can't do this one sliver of the work. And maybe you guys can talk about it more, but I'm all for every person in family law getting that training.
That's actually an excellent suggestion too, because for the screening process, you have
Oh,
to,
yeah,
because that's like literally, I would say,
a lot of the work.
half of my clients, when I start having the conversation about domestic abuse, don't realize they've been victims, and particularly under our more liberal standard in California. And now especially with the coercive control element being added this year. So
Well,
I like it. I think that's a great idea.
I think it should. Otherwise, I think the family law endorsement is going to get too bifurcated or splintered. I think if they're going to be able to do family, since this is the main category, it seems like every program offers. I think that you construct that endorsement as making it that the person who actually can graduate in that endorsement can do just about anything you are considering for them in scope of representation.
Got it.
Do you have any thoughts on that, Claudia?
I agree. I think that having that component be a requirement of the family law is very important. You never know when issues like that may come up. So being prepared is key.
I agree.
Right, you can't screen for it if you don't know to ask the right questions, and someone may not get directed that they need to bring a restraining order request if the person that's dealing with their family law matter hasn't yet a suggestion. So as usual, stellar suggestion, Julia.
Thank you, Stephen.
Thank
I'm
you,
here.
Dan.
I'm affixing your hypothetical gold star. I'm sending an email to Fariba right now too about that.
Okay.
Okay. And we have our that's one of the several meetings we have tomorrow. So
Yeah. I'm sorry, Linda, apologize.
And I just wanted to suggest if either Julia or Claudia, if you're available and want to, participate as a viewer to that meeting, to see what happens tomorrow, and make any public comment, you're welcome to do that.
Thank you.
Thanks. What time is it at?
The family, oh.
I'll check. I can find it probably quicker than
I've got 3 things going on right now on my
12
screen.
o'clock.
So yeah. What's that?
I've got it from 12 to 1:30.
Okay, yeah. We have 3 subcommittee meetings tomorrow. So
Wow.
I'll see what they are tomorrow. And then in terms of the requirements for the supervising attorney, we pulled this off of the practical training of law student requirements. I think that's where the agreement was. There was a question about whether the supervising attorney should be licensed for 3 years or 5 years or 2 years. I think this is where we ended up with 3 years.
Yeah, and I think that's also the requirement for paralegals, that if they're going to get a declaration from an attorney, when they're going to work under an attorney, that was one way they could become a paralegal, and the minimum requirements for that attorney's experience was 3 years.
It's been a while since I looked, but under the law office study program, is it 3 years experience for the attorney that's supervising?
I don't know. I only know
You
from
remember, Linda?
the Business and Professions Code.
All right, hold on, let me look it up. It's got to be the same as that. I don't know that it's got to be.
Yeah, we don't want anyone with less than 3 years of practice.
Right. I just want to make sure that's what it is. I'm surprised that it's 3 years, but okay. I'll keep looking at this where we talk about something else. I'm not sure if I'm
You
gonna.
know what, I think I just, I realized that I neglected to add to that slide. I'm sorry, I keep jumping around, trying to manage this. I wanted to, the requirement that the supervising attorney submit a written declaration.
I'll just to add in, the provisional licensing rule that we just approved for the 2020 grads. There's a 4-year licensing requirement for the supervising attorney,
Oh,
for whatever that means. I think that actually, and I'll look it up right now too, but I think that was patterned on the multi-jurisdictional practice rules.
Rule 4.29. I'm a little wary about the 3-year.
Do we want to change it up to 4 years?
well, if that's what the provisional requires, I think we shouldn't go lower than that.
Yeah, I'm checking Rule 4.2 regarding the law office study program.
And I'll just add, so that I can read this out and send it to you all, or maybe Linda can.
I
It's the
have it.
new rule of court 9.49 I1B. Have practiced law for at least 4 years in any United States jurisdiction and have actively practiced law in California or taught law. This part was actually added after public comment because a number of commenters noted that some people will be obtaining or supervised practice requirements under the supervision of a law professor, taught law at a California law school for at least 2 years immediately preceding the time of supervision, and be a licensing in good standing of the State Bar of California.
I have an email dated Thursday, November 5th that I think it came from you, Linda. So maybe Stephen has that also. It's where they talk about the apprenticeship, and I see that rule under the requirements for supervising attorneys.
And there I'm seeing under the, if maybe this is an old rule, but the one I'm looking at says 5 years. The attorney has to be in active practice for 5 years.
I think that was for the, not the practical training of law students. That was for the
Oh, the law office study program. That's what
office study program. Yes.
Okay.
And then in that same email, we have the requirements of what the signed declaration must consist of and what they must attest to.
Mhm.
So that seems like some very good guidance.
So does this more accurately reflect what I made these changes just now?
Yeah. So greater than 4 years or 5 years, Julia? Claudia, I'm sorry. I'm used to just asking Julia questions, Claudia.
Okay, so you said 4 or 5 years?
Yeah. How long? So the 5 years comes from, that's how long an attorney has to be in practice in order to do the law office study program.
Right.
Someone matriculates in a law office or a judge's chambers. The 4 years sounds like that's from the provisional licensees that are coming in.
I don't think we need anything more rigorous than has already been set forth in this provisional licensure program, because if they already had to respond to public comment, we can assume that anybody else, I can't imagine why here they would require more. And 1 more year, I don't know, between 4 and 5, if that's substantive, but I do like the 4 years at least.
Yeah.
I just want to make sure that we're making it too difficult for the attorney who's willing to bring in some folks.
Right. I mean, if we could say 5 years would be preferred, but with a minimum of 4 years, I think that would be nice.
I think when writing this, sometimes, especially knowing that it's for lawyers and legislators, making it very straightforward and not wiggly or wobbly.
Mhm.
I think we just come up with the threshold minimum,
Yeah.
and then, you know, the applicant, if they have a choice between one setting or another setting, maybe we'll choose one or the other.
I just want to provide a little background on the provisional licensing rule. So to become a provisional licensee, you do not have to be practicing in California. You have to be practicing California law under the supervision of a California licensed attorney, but they could be in New York doing that. So that's the reason I think that this rule was written, that the supervising attorney must have practiced law for at least 4 years in any US jurisdiction and actively practiced in California
Okay.
or law school for 2 years immediately prior. That makes sense.
Okay, so
Yeah.
that's an additional, I like that, a criteria. And I think the 4 is good, Julie, because if you think about it, 5 years is so that someone can become a lawyer.
Mm.
Right? So I'm okay with doing the 4, but I think there's I'm just trying to remember, I had a completely different track, but I think that the difference between 3 and 4 years of experience is significant. It tends to be exponential that first 5 years.
I agree.
So I'd say, Linda, to add that additional condition that Gregory just recited, that 2 years in California.
Immediately preceding the time of supervision.
Right.
There you go.
And be in good standing, obviously.
You can see my bad typing since I'm doing this live. It's fun. Is that accurate now?
Period of supervision and currently be in good standing with this California bar. Is that correct, Greg? Is it the California bar or be in current good standing in any state? I mean, I assume we're wanting them to be in good standing in California because we're creating these folks to work in California law.
So,
Yeah, go ahead.
So the language in the rule of court says good standing.
Good standing of the State Bar of California. That's what it says.
Because
Be a
my
licensee,
understanding is that the California State Bar doesn't have any such thing as good standing. Either you're actively licensed or not.
That term is used quite a bit, though.
I know, but it's interesting because, like, from what I've heard, when people ask for a certificate of good standing, the State Bar corrects that and says it's a certificate of standing. That term, there's not any such thing as good standing. So I think.
So can we say active, an active California license?
And actively licensed in California?
Yeah.
And hold an active California license? Yeah.
Yeah, because the only thing is, say you have a private reprimand, aren't you still considered actively licensed, Greg?
A reprimand, well, that's actually, you mean like an admonition or a reproval? Those are what they refer to. So public approval.
Yeah,
approval.
that's what I meant.
Still in good standing because you're able to practice even with a private or public approval. It appears on your attorney profile, so people can see it on the website. I don't necessarily, gets into what Linda's talking about. There's really no good definition of good standing. Good standing, I would always mean that I interpreted that to mean that you're licensed to practice.
Yeah,
So
let's just,
your license is not suspended and you haven't been disbarred.
And that's where I think this is clearer language, hold an active license to practice.
Yep. I don't think we get into the minutia of folks who can still practice law under perhaps not the best of situations because they're undergoing some sort of possible discipline. But I just think we get too much in the weeds, it's going to be hard to implement. So I think this is really what we can, I think, reasonably expect of someone who's willing to supervise one of these candidates.
So,
thank
so
you,
if
Linda, for
someone
pointing it
can
out.
be on probation
What's that?
and hold an active license, but be on probation. So would the court consider that someone who's on probation not to be in good standing?
The bigger policy question is, would the court want an attorney on probation to be supervising these individuals? And I'd hazard a guess without presenting it to the court that they would not want somebody that's on probation necessarily supervising these individuals. So
maybe we should clarify that, and maybe that's what the good standing.
There you go.
refers to, even though it's not it's not really a legal term, and there's not a category of good standing or not good standing legally, but maybe we should say active license.
Not on probation. And not on
Non-probationary?
probation. That sounds good.
Okay.
And thanks for pointing it out, Linda, because we may want to change this rule and try to figure out where else it's good standing in our rules and clarify that.
And wouldn't it be actually not on probation or suspended? Because when you're an active licensee, suspended, aren't you still an active licensee, just suspended?
Right.
Or is that make you none? I don't
I
know.
think if you're suspended, you're not active.
You're inactive at that.
Yeah,
during that
you're
period.
not active if you're suspended.
Oh, so it actually goes inactive. Gotcha.
Yeah.
Okay.
So a non-probationary active license.
Yes.
Okay.
We could figure out the language for the rule later. I think I need to go
But we
back.
want to clarify that since this is the slideshow that we're going to share.
No, I know, but when the rule language actually gets formulated, I think we
Right.
need to make sure we have it the way we want it.
Okay.
Can I interrupt? I have a question to follow up on what Gregory just said. So Gregory, we're going to have our resolutions and whatnot, and we're going to have our written recommendations, but we're not drafting the actual rules. That's going to be done by the bar afterwards, after they have the finished product, right?
Linda, you can answer that. It's different with each group, how they go about the rule writing process. But Linda, I'm not sure if that's been contemplated for this group or not, how you're going to proceed.
My understanding, and I think, Greg, that's part of the meeting that you have this afternoon, with Leah and the Office of Professional Competence, is that the rule drafting is going to be happening concurrently. And perhaps and I think that's one of the things that we'll be discussing at the meeting in December, is this process. Is there going to be a separate subcommittee that's going to be responsible for working with the appropriate state bar staff and Supreme Court staff to draft the rules? Is it going to be that it's going to be each subcommittee that's looking at licensing and regulation and discipline are going to draft rules? I think that's still to be determined.
Right. So what we're working on later today is, my understanding is looking at the rules of professional conduct, which this type of requirement would not appear in the rules of professional conduct. This would be more of a rule of court.
Right.
And I think normally the way the groups that I've worked with, the group comes to a consensus on the underlying policy and how they want the rule to be applied, and then staff will provide a draft rule. It gets debated in meetings and agreed upon, and then sent to the board. It goes out for public comment. We get a lot of good public comment on it. Things that we're not thinking of. The rule is recrafted, and then the board would approve it. It would go to the court, and then if the court had any issues, they might send it back, or because these are Title IX rules or the rules of court, the court has plenary authority to just redraft it themselves if they want to do that. It depends on how substantive the change would be, but so it's an iterative process. But I think it's much more helpful to really focus on the policy, which we are right now, on the policy decisions that we want to put before the working group, and then figure out how the rules are actually going to be written.
Okay.
Thank you.
So are we done with this? We have agreement from all three of you that this reflects where we stand in terms of the recommendations?
I think so.
Yes.
Correct.
The only thing you might want to add under submit the declaration, and just, you could say, reflecting the requirements that are in the provisional. They set forth what elements have to be in the signed declaration.
So, and I think I can make sure that to include that in the memo that we draft. I don't know that we need to provide.
Okay,
And more than likely, I'm thinking, Julia, this is the declaration is probably going to be formatted and something distributed by the bar. So it's going to have, they'll get into the weeds on the form itself and probably they're going to have to require that.
yeah, I mean, I think there's just going to be, I hereby declare I'm an attorney licensed to practice law in all the courts of the state of California, blah, blah, blah. I mean, I don't know that it has to be a judicial counsel form. It could be, but in any event, that I think the rules should set forth the requirements to support whether or not you want to do a judicial counsel form or not. But if you don't want it here, I don't always remember things I say in each meeting, and to remind me to mention it again.
Right, and I've made a note to include that in the memo that will become the recommendation from your subcommittee to the full
Okay,
working group.
okay,
So here's just, we will want to incorporate recommendations from the practice area subcommittees. And as I said, so far, all we've got is family law. So, and as Stephen can report, and maybe this needs to be modified somewhat, that the family law subcommittee, which is Stephen and Fariba, have recommended that there should be required trauma-informed training in the curriculum for the family law practice area, and also this experiential requirement, as we discussed earlier, on working in a violence prevention clinic. And we would seek similar recommendations from each of the subcommittees as the practice areas are being developed. Okay.
okay.
And so, and then at the last meeting, we talked about that we really wanted to focus on how the incentives for attorneys to provide supervision. And one of the things that was discussed was providing CLE credit, and an acknowledgement that for people who teach CLE courses get credit for that teaching. And so it would make sense if you have someone supervising an applicant to the paraprofessional program that they would receive CLE credit. And you can see it's a little bit different. If you're teaching a law school class, you get 12 hours for every unit of that class. And obviously it's because there's a lot of work that goes into the preparation and the coursework. And it might even, this 12 hours per unit is probably less than a law school teacher is putting into the prep and actual teaching of a course. But then if you have a certified CLE provider and you are coming in either as a guest speaker or you're the teacher for that class, for the first time you present that material, you are entitled to 4 hours of CLE credit. And then if you're presenting the same material at a later date, you get 1 hour for each hour of presentation. So those are models that we can look at. It might be some combination, some sort of hybrid of the two. Maybe the recommendation would be that it would be greater than that, but just wanted to provide that information as a starting point for a conversation about what we think would be appropriate. for CLE credit.
Linda, just a quick question.
Yes.
I don't know this, so what does CLE stand for?
I'm sorry, it's continuing legal education. So
Thank you.
attorneys in California currently are required to complete 25 hours of, and it's often referred to as MCLE, it's minimum or mandatory. I don't know.
Mandatory.
Okay, so it's mandatory continuing legal education for attorneys, and they have to do 25 hours every 3 years.
Okay,
And most
thank you.
licensed professionals are required to complete continuing legal education in whatever field they're licensed in.
Thank you.
And the number of hours really varies. And in fact, the paraprofessional program, the regulation subcommittee is looking at CLE requirements for people once they are licensed as paraprofessionals, how much continuing legal education they would have to complete to maintain their license. And I'm sorry, like we're so used to using this lingo and abbreviations. Apologize for not explaining
Well,
that.
thank you. I appreciate it.
Where did I'm looking at the incentive side, where did the incentive funding come from?
Well, this was just an idea that if the funding could be that this could be, and I don't know where the funding would come from, but again, it could be the kind of thing where we would look for grants for this, that a legal services program could get special funding that would be used to support, if they have paraprofessionals, providing legal services, as part of their experiential training. Perhaps there could be special funding for that. I know that in the fee bill that was passed for the 2021 attorney for your licensing fees starting in the coming year, the legislature approved an additional $5 per licensee. And again, this is the opt-out, the legal services. There's a $20 or it's a $40 assessment. An extra $5 was added on to that. And for the people who don't opt out, whatever that extra $5, that funding is going to go to legal services programs that use these provisionally licensed attorneys. So something similar could be done for paraprofessionals doing their experiential training. It's just an idea that I was trying to come up with what some incentives might be. So it's just as a starting point for discussion.
Well, I definitely think the more opportunities to get CLE or MCLE credit for any attorney who's, taking the time to teach the aspects of the law, including, ethics are included, all of this. I mean, that's part of the training. I think, just getting some MCLE credits is a really good idea. I wish I got them for teaching in a paralegal school.
You don't? Is that right?
No.
Oh, that's too bad.
Greg.
And in terms of the ratio of do you think it makes sense for it to be 1-to-1, 4-to-1, 12-to-1? I mean, well, 12-to-1 is not hours, that's based on units. So it's a
I think that would be too high. Let's see. So would I be offended? The mandatory units, is it 6 or 7 between diversity and the substance abuse, whatever they call that now?
Oh, I don't know. I would have to look.
Here, I've got it.
I think it's 6.
Because I think it was 3, 2, and 1, but it might have gone to 4, 2, and 1. Let me
So
open
what we're talking about now, Claudia, is that there are specific requirements. There's a certain number of hours have to be in ethics and professional responsibility, certain number of hours. I think we have a requirement for diversity.
Yeah.
Well, we have elimination of bias.
Elimination of bias.
And then
4
substance
hours.
abuse.
4 hours have to be legal ethics, at least 1 hour on competence issues.
and 1 on bias. So the total is 6.
And 1 hour on elimination bias.
So in a 3-year cycle, that's 19 units.
And the other thing that the regulation subcommittee is looking at in terms of CLE is to require that paraprofessionals, that their overall training needs to be in the area of practice. Attorneys don't have that. Unless you're a certified specialist, you can do your training in whatever, besides those mandatory hours, you can be practicing family law and take and do your continuing legal education in whatever area you want to. I think most people do their CLE in their area of practice because they want to stay on top of things, but it's not a requirement. And the regulation subcommittee is looking at requiring or recommending that the paraprofessionals be required to do continuing education in their specific practice area.
I think that's a good idea.
Yeah, so in terms of this, that, you know, we could
So this rule's not going to have any impact whatsoever on, unless you say that this is going to qualify as specialization credits, which it shouldn't, because it's not doing higher areas of law. I have to do 36 hours every 3 years, Claudia, just for the family law specialization. And I can take care of my 6 mandatory within those if they're done within a family law area. But that requirement is going to mean this giving CLE credit will not be of any benefit to a specialist. They're not going to be able to do. So I think I would not want to let someone completely do their non-mandatory 6 units by supervising, because then otherwise they're not getting any continuing education except for the mandatory 6. 19, 6. What if you did something like 1 CLE credit for each 1,000 hours supervised?
that's only getting one hour for the
Yeah.
whole
Per individual, for each 1,000 per individual.
No, I think that's too much. I think they got to get more credit than that for 1,000 hours of supervision.
I guess what I'm thinking, Joy, is are you going to want these lawyers who would not be specialists then to do no continuing education outside of the 6 mandatory?
No, I mean, I guess I'm trying to think about what our objective is here. What are we saying? We're specifically talking about the continuing legal education credit for the supervising attorney, correct?
Yes. 6.
And we have part of this being done by the regulation subcommittee as well.
The regulation subcommittee is looking at the CLE for already licensed paraprofessionals to maintain their license. So it really doesn't touch on this.
Okay, I don't think I can come up with a formula on the fly. That I have any, argument to defend. It just seems like right now thinking about it is somewhat arbitrary. But if somebody is going to supervise someone for 1,000 hours, I definitely think they should get not, all of their CLE, but I think they should get a good chunk of it. And I mean, if they have 5, I say they can't repeat those, all those credits with 5 different people they're supervising. There's still going to be a requirement to take some CLE beyond the 6 units. So I think they should though be able to achieve, somewhere near half their units if they're taking on the responsibility of supervising a paraprofessional for 1,000 hours.
I was thinking about a cap of 4 CLE units per year. So over the 3-year cycle, that would be 12. Then the 6 for the mandatory would bring them to 18. So they'd have to take 1 to 2 to 3 other courses to get 7 units outside of the mandatories and the supervision of a paraprofessional. Does that sound reasonable?
I don't know. In my experience, when I need 1 or 2 credits, I take sometimes some silly things that really don't help me very much just to knock it out.
Okay.
So, I mean, I think to incentivize these folks,
I think that there should be, who handles the continuing education at the bar? Is that one of your tasks, Greg? Or is that a Brady issue? Or
That's our attorney regulation and consumer resources.
I think, like, is there a person that you guys could go to there and find out, does it offend them at all if an attorney was going to be able to get all of their CLE other than their mandatory units through supervising a paraprofessional?
Well, I think that office is responsible for ensuring that people are compliant with the regulations that are in place. They really don't have that much input into the substance other than determining whether a course meets the specific requirements.
Okay.
Who is the person or persons, who are the persons that decide on these kind of substantive hourly requirements?
Well, ultimately, the court approves, it's the court's program, but in terms of within the state bar umbrella, Linda, wouldn't that be the Office of Professional Competence that handles any recommendations to the court changing the MCLE?
Sure. Okay.
Because they would have to approve this too, right?
Well, ultimately it would go to the Board of Trustees for approval.
Okay.
By the state bar, and then recommend, which would be a recommendation to the court, and the
Okay.
court would ultimately have to approve any changes to the way it's.
So I think it would be helpful, before we just take a stab in the dark, to get some kind of even basic recommendation from that office over what it is that we're contemplating here.
Mm-hmm. Okay.
Because I think we
Well, I
want
can take
something
the-
that's supported by not just the three of us coming up with it. I think we need some expertise in this area.
Okay, we could, if you want, we can ask someone from that office to come to the next meeting. I think we have that. Do we have another meeting of
Is tomorrow?
this?
Maybe tomorrow, I'm not sure.
Oh, I don't think we have another meeting of this subcommittee, do we?
I think we're going to need one more, because
Yeah.
I think we should schedule one more, just because I, quite honestly, Linda, was not able to go through all the materials that you've sent to us about the curriculum. And I was going to ask to see if but I know this is kind of out of order, but I want to talk about, I need to spend more time with what you provided from the curriculum. And I also want to know, was there just nothing that you could find on Arizona? Because
Arizona, they're still in the process of developing the program. They're
okay,
still working with the school, so there isn't anything yet developed,
okay.
right?
I don't see anything.
Okay. All right. So we'll have to see about scheduling another one of these meetings. And I'm wondering if any of the three of you, or if you have any ideas, Greg, you're also welcome to chime in, or Brady, for other incentives for supervising attorneys.
Other than a commemorative plaque, probably. I mean, someone's going to have to be, I think that there's going to be incentive built into it, is if you're supervising someone and training them and maybe not paying full boat, if it's part of it's done as an unpaid internship, I'm going to want to supervise 3 or 4 and then cherry pick the best one to come work for me.
Yeah, but they also have still some employment requirements, such as work comp and other things. I used to run the internships and work experience, and I no longer do that. So I'm not sure of what all those requirements are, but even for unpaid interns, there is some risk of liability on the part of the employer.
Right. I get that. They step inside your building and they slip, you're going to be paying for the slip and fall. But
They
I guess
get
my
carpal
point being
tunnel.
is, I think it's going to be incentivized in the sense that, you know, I haven't ruled out teaching at one of the paralegal programs, Julia, for that reason, is to be in the classroom and see who the shining star is so I could recruit them. So I think there's going to be, I think that there will be attorneys that realize this is going to become part of our practice, and that is going to become part of our staff, and there'll be an incentive that way to do this.
I have a question, just in regards to the incentives. I know on the State Bar website, there's a section for consumers where we can look for attorneys. Is it possible to maybe place an asterisk on some of these folks that are training others? That could be a point of choice for some consumers, maybe wanting to seek the help of somebody that is being entrusted with the training of others.
That's a good point, Claudia.
Yeah.
Thank you.
I think a service directory, I don't know that you would do it in our general listings, but having a provider list that says we are training or employ paraprofessionals and have a separate list.
Sure.
Because for a consumer to be able to figure out if they want to have a law firm, but they don't want to pay the attorney rates, but the paraprofessional rates, that would be an incentive to do the supervision, because those people you're supervising are going to be generating work product.
Right. So I don't know if any of you have seen, but there's now a way to search for provisionally licensed attorneys on the State Bar's website, and that does have a link to who is providing their supervision.
Well, there you go. I think
Look up, if you look up any provisionally licensed attorney, it's actually it's really well set up, and you click on their name and it shows you who's providing their supervision, and it takes you, you can look at the link on their site, on their
so.
page.
What we could have is a link for the certified paraprofessional. Then once they're listed, a link to where they did their practice or experiential training.
Right, right, right. Any other ideas?
So I think you could put I guess I would just call it directory under the right side.
Okay, let me just. Does that accurately reflect what we've been discussing?
Yes. Because I mean, I think then you could also, in that same link, if that paraprofessional completed where they completed and are now working somewhere else, you could have like another address saying currently. I mean, just like we have to register an address for the State Bar, they could register where they're currently employed. But I think the incentive is to give these attorneys who are willing to do this, some note of training. I mean, I know we can't endorse them, we have to be careful, but at the same time, it's just simply to list where this person got their training and where they currently work.
Hmm.
But I did envision that they were going to have to maintain contact with the State Bar just like attorneys would have to.
Yes, if they're licensed by the state bar, there would be something similar.
Yeah.
Well, that's sort of takes us to the end of the slideshow I prepared, and I know we've got another half hour to this meeting, and we talked, and Julia, you talked about wanting to go more through, review the curriculum that we've seen for other programs. I don't know if you want to do that a little bit today, if you want to set another meeting. And if you want to set another meeting, if it makes sense, if that's something that you feel needs to happen in advance of the full meeting of the working group in December, because it would inform your recommendations, or if the recommendations are going to say that this subcommittee will continue to meet to flesh out the curricular requirements, especially because we're going to need the input from the other practice area subcommittees in addition to family.
So if what you're saying is, even though we send over our memo, and remember, we need to make sure whatever we gave previously, we eliminate that
Yes.
evidence was a required course,
Yeah.
that we, if it's acceptable to the group that we are continuing an ongoing work on the aspect of curriculum, I'm not going to say that we necessarily need another meeting before that meeting. If others want to spend more time on this, I'm just thinking, we just had a holiday weekend, and that kind of is where I got, didn't have a lot of time to deal with this last night, but I know that this is a month that, even though it's COVID, there are going to be some other distractions around. And I think I'm, for example, ending up a semester the week before the week of our meeting. So I'm in the last 3 weeks of my semester. So I'm not looking for extra work if we don't have to do it in December. But if it's preferable, I'm willing to offer a couple of dates where we could meet again.
And it would have to be at least 10 days from today. And I think that's pushing it up pretty close to the meeting of the working group, especially if we want to have post the recommendation well in advance of the meeting. I think that makes it hard. And I do think that it will be helpful to review the descriptions of the courses, but I do think that it's hard to imagine that your subcommittee is going to be able to develop all of the requirements, the curricular requirements, absent input from the substantive practice area subcommittees.
So if I end up wanting to contribute something after, because what I'm doing is I'm kind of comparing them, because if we recall, Washington State, if I'm not mistaken in my belief, they're like the only jurisdiction that were allowing non-paralegals into their program. So they could have a BA or an AA in anything and then start their program. Whereas every other program wanted someone with a legal background previously. So what I was looking at in Washington was very interesting, but then I got a little bit stuck because they were listing their paralegal courses right along the paraprofessional courses, and our candidates are already going to have at least the paralegal education. So the way they're presenting it is a little duplicative, I think. We're looking at this as a continuation of what our candidates already have. So sorting through that, and especially with the civil procedure and the practice areas that Steve and I initially talked about, I want to really take a look at what more did they require of candidates other than the in addition to the paralegal training. So I'm trying to take a look at that. We kind of modeled a lot of what we did looking at Arizona. We liked the different ways they enumerated their endorsements, but if we have no curriculum from them, I think Utah, Washington, and Ontario are helpful. I just may have some thoughts before the next meeting, and I'm not sure, based on the requirements for these meetings, can I share those in writing with anyone, or do I just reserve them for the big group meeting?
I'll leave that to you, Brady.
Well, because this is a Bagley-Keene subcommittee, this licensing group, you couldn't, and there's 3 members, you couldn't share it with any other member of this group without violating Bagley-Keene, because you'd be sharing it with the majority of this group. So it would be best to save it for a noticed meeting.
Okay. Well,
And if I can give you a little bit more information about the materials that the curriculum descriptions. What I did was Julia, you very helpfully pointed me to that where I could find a list of all of the schools in Washington that had been providing this paraprofessional training program. And all of them, you know, when I went to their websites, they say, well, this program was sunset by the Supreme Court of Washington. It's no longer available. And at first I kept feeling like I was coming up against dead ends. But then I went back and looked at what their educational requirements were for the program. And I could see they're still teaching those courses. So that's what I provided, was the course descriptions. For the other schools, I did something, you know, if they had specifically a paraprofessional licensing program in the other states, then I went and pulled those programs. And as I explained, I think before the meeting really started, and I was having sort of a conversation with some of you, the programs in Canada, it's hard to get at the course descriptions. They don't publish their catalogs online. Some of them, and I wasn't even able to print them off their website, even printing the pages from the website. But if you have time and want to spend some time looking, if you go to the Ontario program, there are links from the Law Society of Ontario's website that shows you, like, these are the schools that have the programs, and you could do a little research yourself. I just couldn't figure out a way to bring that to you in print.
well, and what you did provide with Washington is very helpful, because they give the description of there are people still in the pipeline going through this program. So they're still actively educating these paraprofessionals. It's just going to sunset where they're not going to enroll. They stopped enrolling students in June of 2020. So they're still doing this, and I'm still taking a look at what they've done in the past, and I'm still trying to consider what really, you know, I mean, why did this not work? If I can, I just want to make sure that, you know, we're learning from others' past experiences, and we're getting to the point where we can figure out some of the vulnerabilities. And I'm sure that had to deal with cost. And I just want to make sure that we can enhance our model to meet any of those challenges, so that it's a success and not overly complicated, so that it'll move forward.
Well, what I'd like to suggest is that I can draft a memo from your working group that captures the recommendations and where they stand so far. If you're ready to go forward with recommendations, or if it's going to be like at the October meeting where there were just updates. But it seems like there are certain areas where you really have really solidified recommendations, and then say this, and so say these are the recommendations from our subcommittee, and ask the working group to vote on those recommendations that are completed, and say, and this is the work that we're continuing to do, and we're reviewing curriculum from other programs. So one of the areas is the specific curriculum, and that also that you'll be seeking input from the practice area subcommittees on specifics. Does that sound like a good way to go?
That's good. I would just also like to include that we're awaiting a contribution on the MCLE
Yes.
incentives, that we would like some guidance to address that.
Yeah, I think the two areas that we don't have done yet, Julia and Claudia, would be the incentives and then the specific academic requirements. And the latter, we're waiting for input from the practice areas subcommittees to give us some recommendations.
Okay.
or input.
Linda, didn't you say there was a third one? Or is it only two?
I think those were the two. And the other thing that would be useful with the incentives being in still being in development, there might be other members, like Claudia had a really good idea. There might be other members of the whole working group that have some ideas.
Yeah,
And in fact, if we put this in the memo, and the memo is posted in advance, and there are members of the public who read it, there might be people who come and make public comment
sure.
and have some ideas and contributions.
Well,
Okay.
I'm fine with that.
Oh, so what I'll do, and Claudia, since you're relatively new to this, I'll explain to you the process. What I will do is I will draft a memo and circulate it. I'll send it, and in fact, it can't really circulate among you. I'll send it to each one of you individually and ask you to directly respond to me with your comments, edits, changes. And then I'll make those revisions and send it out again. And the goal is to get all of the memos, the recommendations from each of the subcommittees posted well in advance of the meeting on December 17th.
Thank you.
Okay.
All right. That
Anything
sounds
else?
good. Well, all I ask is that if you have anything else, Linda, that you do find out about Arizona or anything else, because I don't know how much more time I'm gonna spend searching for things, but all the help on the curriculum, the better, because I noticed that Stephen and I, when we talked about practice in the past and that kind of training, I found that it was interesting, just as an example, to note how there was specific coursework regarding alternative dispute resolution, negotiation, mediation, and arbitration. And I thought those specific words were very helpful as we try and communicate our thoughts about what those kind of advocacy training looks like. And so reading these curriculum are very helpful.
Okay, that's great. And I have been in touch with the people in Arizona to get information about if they have been developing curriculum, and the feedback I'm getting is that they're working with the schools to develop that program, because as you know, that program was very recently approved by their Supreme Court. So it is in process. The other thing I did ask about is in terms of the experiential requirements, whether any of the states have more detail about the kind of experiential training that's required. And the response I got was that there wasn't anything. They don't have any guidelines beyond what's in their rules.
Okay.
We've seen. Okay. Okay, well, thank you all. And I guess so the next you'll hear from me is a draft memo for your review.
Okay.
Thank you very much.
Thank you.
Yeah,
Thank you,
nice,
Linda.
nice
job,
working
Linda.
with you all. Thank you.
Thank you, Claudia and Stephen and Greg and
Thank you.
Linda.
Take
Thank
care.
you.
I'll so go Waltons on you, Julia.
Okay.
Bye, everybody.
Bye.
Bye.
Bye-bye.